So thank you. It's intimidating being before a bunch of scientists. I'm a lawyer. I am a former federal law enforcement official for 4 years. I ran the Federal Trade Commission's Bureau of Consumer Protection, which, among other things, has jurisdiction over advertising in the United States. And so a core component of the Bureau's mission is to protect U.S. consumers from false, misleading, or deceptive advertising. And the agency focuses heavily on advertising promoting bogus health claims, including dietary supplements, food products that are said to provide health benefits, and various kind of cures for diseases like cancer, diabetes, as well as conditions like alcoholism and obesity. So today I'm going to talk more about an enforcement approach that doesn't focus on the nature of the care that's being provided, but on the nature of the claims that are being made for it. And there are two issues that I want to discuss separately today. First, advertising for stem cell therapies that lack scientific support, but where the treatment will be rendered in the United States. U.S. domestic advertising. And second, advertising in the United States directed at U.S. consumers by doctors, fake doctors, and clinics outside the United States. Okay, so let me start with the basics. Under the Food, Drug, and Cosmetic Act, advertising for treatments based on stem cells that are unapproved by the FDA is a serious infraction of the law. The FDA has the option of proceeding against an entity touting stem cell usage for unapproved uses, either through civil or criminal law enforcement. And depending on the circumstances, civil actions can begin with warning letters, and if they're not obeyed, then escalate to lawsuits seeking injunctions, seizures, and other orders directly regulating the conduct of those involved. In cases that the FDA thinks pose more of a significant threat to human health, the FDA also may proceed criminally. And it has just done that with respect to unapproved uses of stem cells. In September 2012, the FDA obtained guilty pleas against 2 individuals who ran several businesses advertising and promoting the use of stem cells to treat ALS, multiple sclerosis, Parkinson's, making your blood boil, using a variety of tools, including dietary supplements, vaccines, and more pertinently here, stem cell therapy. Now, the point of this prosecution for the FDA was to send a warning shot across the bow of those who would follow in their footsteps and make it clear that recurrences of this would be met by further criminal enforcement actions by the FDA. And the FDA was not done. Just this summer, the FDA obtained a guilty plea from an assistant professor of pathology and laboratory medicine at the Medical University of South Carolina for, quote, causing the introduction of stem cells into interstate commerce without the approval of the FDA. Now, the laboratory the defendant worked for was in fact authorized to conduct research on kidney cancer, but it was not permitted to use or harvest or process stem cells for other purposes. And the defendant sold stem cells to unauthorized recipients. He will be a guest of the state for a while. So like the earlier case, these prosecutions are aimed at sending a clear signal to doctors, scientists, technicians that this is an important issue for the FDA, and the FDA will enforce them with a special rigor. So that's one part of the enforcement tool. The Federal Trade Commission, which I used to work for, works closely with the FDA on these kinds of matters. Generally, but not always, the Federal Trade Commission has principal responsibility with respect to advertising, while the FDA worries about promotions on packages, through websites, and other means of distribution. Now, I know that stem cell therapies are often promoted heavily on websites, and each agency has independent authority over internet marketing. But just so you understand that where you're dealing with an emergent scientific issue like stem cell research and stem cell therapies, The FTC, which is not a science agency, is going to look to the FDA for guidance on these issues. But here's the rub. The Federal Trade Commission does not enforce the Food, Drug, and Cosmetic Act. It enforces its own statute, which sets a demanding standard, in fact, a more demanding standard than the FDA. With respect to health claims, the FTC can act only if it can show that the claim is false or deceptive. Now, where you're dealing with health claims, the issue is whether there is substantiation, adequate substantiation to support the claim. That is it a scientifically valid claim? For the FDA, the question is simply a binary one. Has the FDA approved the therapy? If not, it's an unapproved use. The advertising sale of the product is illegal. For the FTC, the claim is a scientific one. Is there adequate substantiation in the scientific literature to support the claim? If the answer is yes, the FTC cannot act. If the answer is no, we can. So to date, the Federal Trade Commission has not brought an enforcement case regarding the advertising of stem cells, unapproved or unsubstantiated stem cell therapies. And I think I can say, without any fear of contradiction, this is not an issue that has been teed up before the FTC. We received either no or virtually no complaints about stem cell advertising during my tenure at the agency. And that may suggest a number of things. First, despite the proliferation of clinics abroad offering these therapies, and I know there's been a quantum leap in them, there may be only a limited number of U.S. patients availing themselves of these clinics. And the studies that I reviewed for today's event have virtually no information about the extent to which these clinics are being used by U.S. citizens. Second, it could be that the U.S. patients that have used them do not believe they've been misled or harmed. And in the absence of some claim of injury, no federal agency is going to take action. And the last is, of course, that these patients either do not, are unaware of the complaint mechanisms that are available or think that complaining would be futile. But in any event, this is not an issue, I don't think, that's yet on the radar screen of the FTC. But let me say also that the companies involved in advertising stem cell therapies in the United States are doing so with a clear-eye understanding of the law here. So if you look at the typical site, there are a litany of disclaimers tailored to escape U.S. regulation. So this is one site. Let me just read you, and this was most of the site. Quote, "The statements, treatments, and other information on this website have not been evaluated by the U.S. FDA." Next, quote, "The stem cell protocols we offer are not approved in the United States as treatments, therapies, drugs, new drugs, or investigational drugs." Next, "We do not claim that our treatment protocols are approved by the U.S. FDA or proven to be effective in the United States for any condition that appears on this site or for any other condition." I keep on going, I'll give you one more, but this is on one website. This is 80% of the website. Quote, "There could be significant and unknown risks associated with adult stem cells treatment, as long-term studies have not yet been performed. Very few randomized controlled trials of adult stem cells have been performed. Therefore, no guarantee of safety or effectiveness is made or implied." So these are sophisticated actors. I don't believe that any of these disclaimers would necessarily defeat an FTC claim, because obviously there is a claim that these therapies have some scientific grounding and have some promise, hold out some promise of effectiveness. But these are certainly sophisticated operators who understand the dynamics of U.S. law. So the FTC bases enforcement actions on a number of sources of information. 3 are relevant here. First is we get about 2 million original complaints from consumers each year, and we analyze this data very closely on a daily basis. Stem cell complaints don't factor in. Second, we get referrals from other law enforcement agencies, including our partnership with the FDA. Again, stem cell complaints have not factored in. And lastly, we get complaints from trusted sources, like academics and experts in the field. In other words, like people in the room. Again, stem cells have not been the subject of that kind of communication. So to the extent there are concerns about unproven therapies being offered to U.S. consumers, the federal regulatory agencies need to hear from it. We need to understand better the risks to patients, not just the physical risks, but the enormous costs that many of these treatments in scare quotes perhaps, cost. But these are important issues to an agency. And there really is a one-stop shop. The FTC does manage a complaint system that is shared widely with federal regulatory agencies, every state attorney general, and consumer protection agencies across the country. So that is one place to do it. I see my time is quickly expiring. Let me just make two last quick points. One is the FTC spends a lot of its time going after bogus claims for medical treatments and cures. Within 2 weeks, we shut down a clinic in Florida that claimed that the clinic's team of doctors would create a customized and permanent cure for alcoholism. And the claims talked about the best technology to end alcohol abuse permanently, scientifically proven to cure alcoholism. But of course, there was no shred of substantiation for any of these claims. We shut the clinic down, we took all their money and returned it to consumers. The next week, we shut down a group called the Wellness Support Network, also at least purportedly run by doctors, who had invented a new treatment for diabetes. They billed their product as being based on Nobel Prize-winning technology, based on scientific breakthroughs. And they told people with diabetes they could end their diabetes, and people who may have been heading to diabetes, they could prevent it. Again, we shut them down, took their money, and returned it to consumers. So it is not that the FTC is unwilling or disinterested in this issue. It just is not an issue that I think is ever really brought to the agency's attention. Let me make one last point, which is it doesn't matter to the FTC whether the company is physically in the United States. If the company is selling a product in the United States, we will go after them. We went after Iovate, which is one of the world's largest dietary sub-manufacturers, for making unsubstantiated health claims in the United States. For example, in anticipation of the H1N1 flu epidemic that never really hit, they claimed that they had medications that would prevent you from getting the flu, not vaccines, dietary subs. The problem for us is when all of the activities are offshore. Now, there are two categories of cases that arise there. One is when the activities are illegal in the host state, and the other is when they're legal. If they're illegal in the host state, that makes it easier for the FTC because we have, as most federal agencies do, we have counterparts in regulatory agencies in most of the other countries of the world. And if an actor that is trying to lure US customers is also doing business in their country, well, they too have an incentive to take regulatory action. And we've been somewhat successful where the underlying activity is illegal in the host state. Where it is legal is a real problem for us because we obviously can't depend on the cooperation of the host country. That doesn't mean, however, that the FTC is powerless. We still can go after the advertising in the United States, and we can still go after the advertising in the United States, even if it takes place over the internet. There are ways of putting the media outlets that convey this information on notice that we believe it's false or misleading. And a media outlet that disseminates false and misleading information may well have liability under the US laws. And so even in what I think is the hardest case for the FTC to act, where the activity is perfectly lawful in the host state, I still think there are ways of attacking advertising that's demonstrably false or deceptive. So I've more than exceeded my time. Thank you very much.
Thank you. And what I'm about to say, by the way, George should not take personally. I've been asked to really stay on schedule, so I will be once the red light starts flashing. But that wasn't directed at anything I know about you, George. Our next speaker is George Daly from Harvard University.